Hi, everybody. Welcome to the California Lawyers Association Privacy Law Section's poolside chat about the FTC and health data. My name is Sherry Porath Rockwell, and I am the chair of the California Lawyers Association Privacy Law Section, and I am a privacy lawyer at Sidley Austin. However, I am here today in my personal capacity and do not represent the views of Sidley Austin in any way. It is my absolute pleasure to be joined in this poolside chat with Ronnie Solomon, who is actually at the other end of the country in Washington, D.C. Ronnie is an FTC attorney who was the lead attorney on the GoodRx enforcement action that really kicked off what I'm calling the year of health data privacy. It seems that 2023 is really shaping up to be that year, with several cases we will talk about brought by the FTC, and then followed by a rash of health privacy legislation that passed in Washington State, Nevada, and Connecticut. So it's, I know, top of mind for all practicing privacy lawyers, and we're so thrilled to have Ronnie with us today. I'm going to let Ronnie introduce himself, but as an aside and just a plug for joining the privacy law section and getting involved in what we do, I first met Ronnie just a couple years ago virtually during COVID through CLA, through the privacy law section. We were working together on writing some chapters in a book. So you never know who you're going to come across in CLA, and it's a very gratifying experience. So consider joining the privacy law section, and more importantly, getting involved. Okay, I am now going to turn it over to Ronnie to introduce himself, and we'll kick off this discussion.
Thanks so much, Sherry. So excited to be here and with CLA. As you can tell, I'm currently poolside at the FTC pool with my margarita. So my name is Ronnie Solomon. I am an FTC attorney. I am in the Bureau of Consumer Protection in the Division of Privacy. I've been at the FTC for coming up on 7 years. And my work focuses on data privacy and data security cases, investigations, litigation, and policy. I'm also a member of the California Bar. I started my career, in the San Francisco office of the Federal Trade Commission, and then transitioned to the DC headquarters to focus on privacy and data security work. I think, Sherry, you put it great when you said it has been the year of health data privacy. I think that is no understatement. The FTC has really made a big splash in this space in an area that, in my personal opinion, was really ripe for data misuse, data abuse. We've announced a slew of enforcement actions, from GoodRx to BetterHelp to Premom to Vitagene. We've updated our health breach notification rule to really bring it into the 21st century and make sure companies are on notice of their obligations. We recently announced a letter campaign to approximately 130 hospitals and telehealth platforms. So we're really sort of making sure that companies that operate in this space know the law. We've also issued a lot of recent guidance so that businesses have something to go by and to reference with respect to handling of really sensitive data like personal health information.
Great, thank you, Ronnie. And I omitted one housekeeping measure announcement, which was to say, first, as you all know, when you signed up, this is being recorded. But we are not taking questions. Ronnie's with the FTC, and as you all know, it's very hard for government lawyers to really say too much. So we thought it best to not have questions asked by the audience today. All right, well, let's thank you for that overview, Ronnie. And why don't you just give us a quick overview about the FTC and its role in enforcing data privacy law in the US?
Sure. And just as a quick sort of housekeeping item, I just want to disclaim that anything I say today does not represent the views of any individual commissioners or the Federal Trade Commission at large. I'm just an employee. So we at the Federal Trade Commission, we are a law enforcement agency And on the consumer protection side, we do a host of consumer protection type cases ranging from fraud to false advertising to financial products to here data privacy. As you know, there is no national baseline national privacy law in the United States. The states like California do have privacy laws, but there is nothing uniform that applies across the country. And so we at the FTC enforce data privacy through a few different ways. Our main tool is our sort of main statute, Section 5 of the FTC Act, which prohibits unfair and deceptive trade practices. We also, in some cases where Congress has granted us authority to promulgate specific rules, we have certain rules that we enforce where we can get civil penalties. And we'll talk about one of those in the health context called the health breach notification rule. But sort of turning to our main bread and butter sort of workhorse, Section 5, again, that prohibits unfair and deceptive trade practices. So what does that mean in the data privacy context? So when we talk about deception, we mean when companies, deceive consumers, don't tell the truth, or misrepresent their data practice, their data policies with respect to how they collect, use, or share personal information. A lot of us, we use apps, we use websites, and we see those long, sometimes confusing privacy policies. Here at the FTC, we lawyers actually read those and expect companies to hold to those promises they make to consumers about how they treat data. Unfortunately, many companies do not, and you often see the FTC suing companies for failing to live up to their privacy promises and their privacy policies, for example. The GoodRx case, which we'll talk about today, is one example of that. And then second, the second part of Section 5 is unfairness, which just in a nutshell, practices that are substantially injurious to consumers that don't have countervailing benefits. Something to point out here that's really important is when we talk about unfairness, we're not necessarily talking about the promises you make in your privacy policies to consumers. Unfairness is sort of its own category of practices that in and of themselves, regardless of your disclosures and your privacy policies, we consider to be sort of unfair and injurious to consumers. Just to give you a few examples of practices that the FTC has said are unfair more recently, for example, sharing sensitive data like health information without first obtaining affirmative express consent from consumers. Another data practice that we've said is unfair is companies that collect, use, and share sensitive health information, failing to have internal written privacy programs and compliance programs to protect the information from unauthorized disclosure. Just another example, again, of an unfair practice is making material retroactive changes to your privacy policies without notifying consumers of those changes, kind of making slide changes on the back end that consumers didn't have a chance to review or consent to. So that's a little bit about how we use Section 5 in the data privacy context. One of the specific rules in addition to Section 5 that we enforce is called the health breach notification rule. This is a breach notification rule that requires companies that collect personally identifiable health information and a personal health record to notify consumers, the FTC, and in some cases the media, anytime there's been a breach of that information. And that could be a breach like a hack or theft of or misappropriation of information, or it could be companies that voluntarily and intentionally share information, but do so in a way that is unauthorized and not consistent with their policies and disclosures. Where companies fail to notify consumers where there's been a breach, they may be liable for civil penalties and may find themselves on the other end of an FTC enforcement action. So, if the FTC does come knocking at your door, what can you expect? We conduct thorough investigations. We normally collect information through compulsory process, subpoenas, deposition testimony, and the like. And if we determine that there has been a law violation, that can result in either a negotiated out-of-court settlement or a lawsuit filed in federal or administrative court. Our relief is often injunctive and often monetary as well. So that's a little bit about what we do for consumers and protecting the American public.
Okay, and we're going to unpack some of those concepts, certainly the health breach notification rule, how it was used in GoodRx. Before we do that, though, I just want to turn to the unfairness prong, where you had said that certain uses of health data the FTC considers to be unfair within the meaning of the FTC Act. And I think that's a little bit, this is kind of a new development in terms of how the FTC is defining health data. So I think that would be very important if you can tell us what is health data, personally identifiable health data. How is the FTC considering that these days?
Yeah, so we're taking a really broad approach as to what health information is, right? It can be anything from which you can make a conclusion or an inference about a person's health. So oftentimes when we talk about health information, people think of HIPAA, and HHS, Office for Civil Rights, enforces that. HIPAA is narrow in its scope. It only applies to healthcare providers, insurance companies, hospitals, and the like. But the thing is, you might have a conversation with your doctor about a medication or a diagnosis, and it's covered by HIPAA. Once you take that same information and put it into an app not covered by HIPAA, it loses a lot of the protection under that statute. So we at the FTC sort of make up the difference and sort of take a broad view of what health information is. So this can be traditional health information, but also things like your inputs into apps and websites, your browsing data on a health-related app or website, things like fitness trackers, medication-related apps, weight loss and fitness apps, ovulation trackers. It really runs the gamut. And again, anything from which information can be inferred about your health, we would consider to be health information. When we talk about, inferring health information, context really matters. So you might have a piece of information that by itself doesn't count as health information. So to give you one example, an email address, right? People don't ordinarily think of that as health information, but an email address combined with data showing that you use, let's say, an online mental health platform like BetterHelp, those two data points put together, you can infer that the person may have a mental health condition. And so that's an example of ways in which, ordinary pieces of data can become health information. There's also biometric information, things like your facial recognition, your voice data. There are a lot of companies that collect DNA information that are not covered by HIPAA because they're not covered entities. So I think it's important to know that health information, as we view it at the FTC, is really broad. And one other thing I would point out to the audience is health information is really uniquely sensitive in that, again, not only can a lot of things be inferred from it, but you sort of can unring the bell, right? If you suffer from a chronic condition, you oftentimes suffer from that condition for life. So if you have diabetes or something like that, sort of doesn't go away, and it's not like other pieces of data. So if your credit card information is stolen, you can take steps to remedy that by replacing your credit card. Can't really do that in the health context. As well, there are a lot of harms that flow from the disclosure of your health information, not only stigma and embarrassment, but also potential discrimination by insurance companies, employers, and the like. One thing we've seen is that there is a sort of really budding market for the obtaining and sale of sensitive health information among data brokers. Consumers often don't know that this market exists. People pay a premium to learn information about people's health, and it's largely an unregulated space, and consumers have no control over it. So just want to hammer home, when we talk about health information, it's sort of one of the most sensitive categories of information there is. And we at the FTC here are trying to sort of be the enforcers, the cops on the beat, to make sure that when we talk about health data privacy, companies are really following the law.
So it seems to, so would it be correct to say GoodRx really marked a real shift in the FTC's approach? And was it really the first case that articulated these principles and really broadened the definition of health data by the FTC?
Yeah, I mean, I think GoodRx was a first in many respects for a lot of different reasons. It certainly was a shot across the bow for much of the industry. And I can talk a little bit about the allegations there. So GoodRx was the first in a line of recent enforcement actions we had. For those who don't know, GoodRx is a mobile app website that allows consumers to search for discounts on prescription medications. It also has a telemedicine platform where you can get virtual appointments with healthcare professionals, largely unregulated by HIPAA. We allege in our complaint that over 55 million Americans have used GoodRx and or provided their data to the company. What we alleged was that GoodRx was violating explicit privacy promises it was making to its users. It was saying that it doesn't share health information for advertising, that it takes steps to limit the data that personally identifiable data that it does share. And what we alleged was that wasn't true. And in fact, GoodRx was installing, pixels, SDKs, automated pieces of tracking code onto its website that would collect what a user does on the website, the names of medications that users search for, the health conditions they searched for, the types of chronic conditions for which they're seeking telehealth appointments, and sending all that information along with personal identifiers over to companies like Facebook. That information was all re-identified on the Facebook platform and was used to identify that Ronnie Solomon or Sherry Rockwell take a certain medication or suffer from a certain condition. These users were placed into targeting audiences, what we call custom audiences, and received targeted ads related to the medications or health conditions that applied to them. All this information was viewable by Facebook. It was used by companies like Facebook for research and development purposes. And again, was really contrary to everything GoodRx was telling consumers. So not only was it sharing the information, but something really egregious, it was using it to advertise. So the FTC brought a lawsuit in February of this year. We announced it. And we alleged several things. The first was a host of counts of deception under Section 5. Again, GoodRx was making promises about how it shared information with third parties that it wasn't living up to, and this information was ending up with Facebook, Google, Criteo, and a bunch of other companies. We also alleged 2 counts of unfairness. And again, this was separate and apart from disclosures to consumers about their privacy policies. First, we alleged that it was unfair for GoodRx to share sensitive, personally identifiable health information with third-party companies without first getting affirmative express consent. And second, we allege that GoodRx was essentially not doing anything internally at the company to protect the privacy of its users. It had no written policies in place. It had no compliance programs. It wasn't vetting its third-party data flows. And so we allege that that failure was an unfair practice in and of itself. And then I think the big sort of splash was we alleged for the very first time in the FTC's history that these practices violated the health breach notification rule. This was our first enforcement action under the rule, and we obtained $1.5 million in civil penalties for the failure to notify consumers that it was sharing this information with the likes of Facebook and Google. And something to point out is we enforced this breach notification rule, not in the context of a theft or a misappropriation, but in accordance with the plain language of the rule, a voluntary unauthorized disclosure by the company that was not consistent with the company's disclosures. So
that's and just to clarify, that health breach notification rule, it doesn't apply to just any business, right? It's a certain type of entity that applies to. Maybe you can just clarify that for the people.
Yeah, so it applies to vendors of electronic personal health records who are not covered by HIPAA. HHS, which enforces HIPAA, has its own version of the rule, which is very similar. But our rule specifically covers non-HIPAA vendors of personal health records. It has to be electronic personal health records. And this encompasses, everything from, purveyors of mobile apps to connected devices, any companies that fall under the definition of personal health record or a related entity. It also covers a defined term called, third parties, which are typically third-party service providers. And again, there has to be personally identifiable health information that's being held in this personal health record, and there has to have been some sort of unauthorized disclosure of the information. If all of those things have occurred, companies really need to examine their obligations under the rule and whether or not they need to notify the FTC, the media, and affected consumers.
Right. And I know, so the GoodRx overview, so there were 2 other big cases, or I guess 3, if you include Vitagene as well. Why don't you talk a little bit about the allegations in those cases to the extent they differ from the GoodRx allegations?
Yeah, so I'll talk a little bit about Premom and BetterHelp. Similar cases. In Premom, we also alleged unfairness, deception, and health breach notification rule violations. Premom is an ovulation tracking, period tracking app that collects a lot of sensitive information, like information about ovulation, pregnancy status, a lot of other personal identifiers. And what we allege was very similar to the way GoodRx was sharing information with third parties, that Premom was sharing all this information with AppsFlyer and Google, again, contrary to its promises. We also allege same thing, that its failure to have an internal written privacy and security program was a unfair act. And we also alleged health breach notification rule violations and obtained $100,000 in civil penalties for the failure to notify. And then we also had BetterHelp. This is an online mental health therapy platform. And what we alleged there was that when users signed up for the service, they provided a lot of sensitive information about their mental health. BetterHelp had installed tracking pixels and tracking code on its website to send all that information over to Facebook. It was also used to advertise. And so very similarly, we allege that this was contrary to their privacy promises, that the failure to get consent or have a written privacy program was unfair. And that was an administrative settlement in which we obtained over $7 million in consumer redress.
And going to the programs that you're talking about that are alleged to satisfy the unfairness prong of the FTC Act, talk about the idea of training and in the marketing departments, because a lot of this is just really about ad tech, right? And I know that there were allegations, I believe it was in BetterHelp, but I may be blurring BetterHelp and GoodRx, about the level of seniority of the person who was in charge of the advertising program. And what did the FTC have to say about that?
Yeah, so I won't get too into the weeds in that, but I think the sort of overview there was that, again, the companies that we've been talking about having failures to have written privacy programs, protocols in place, data use limitations, things like that, who has access to the data. We see very low-level employees, like people in the marketing department, having access to really sensitive health information for marketing and advertising. There being no internal data use, access limitations, and the like was part of our allegations for unfairness.
Okay, and then you've kind of touched on it, but do you want to provide just a general overview of what types of, all of these resulted in a negotiated settlement, and what types of relief were negotiated with these companies, and what does that mean for those of us who are practicing in terms of telegraphing information we need to know when advising our clients or helping the companies we work for?
Yeah. So all of these cases resulted in, I think it's fair to say, groundbreaking, novel injunctive relief in the form of negotiated settlement agreements. The biggest piece of these, I think, was the fact that in each of these cases, we obtained a permanent ban on these companies using or sharing health information for advertising purposes. And so the conduct that we're talking about, where GoodRx was sharing really sensitive health information with companies like Facebook, they are now permanently banned from doing that under our order. The companies are also required to get affirmative express consent before they share health information for other purposes, non-advertising purposes. In addition, there are requirements that the companies have to notify consumers of these unauthorized disclosures. The companies are required to implement, going forward permanently, internal privacy and security programs to protect people's data. And there are a lot of safeguards that the order requires as to how they have to go about doing that. They have to hire independent third-party assessors to sort of audit their ongoing compliance with the privacy and data security requirements of the order. These orders also include data retention limits that limit how long the companies can keep data, and require the companies to publish a schedule somewhere on their website or in the app telling consumers how they use data and how long they keep it for. So a lot of these, for example, the ban on sharing of health information for advertising was new and groundbreaking, and one of the first times we've ever really done that in the past. In terms of what the sort of key takeaways are, I think there are a lot. First, I think these cases show that the FTC is really going to be the cop on the beat, is going to be holding companies to their privacy promises, but also examining practices that we consider to be unfair, that really are harmful to consumers and have no countervailing benefits to consumers, competition, or society. And I think using health information for advertising could certainly fall into that category. I think another fair takeaway is that when you collect and share really sensitive, personally identifiable health information, it's on you to make sure that you have an internal privacy program in place at the company, so that this information isn't just being passed around willy-nilly, isn't being disclosed in an unauthorized manner, that you're actually doing what you say in your privacy policies, right? I mean, it's not enough to just say it. You actually have to mean it and do it. So I think that's another key takeaway. As we talked about before, think carefully about whether you need to collect certain pieces of data. As I said earlier, health information is really broad, includes a lot of things like browsing information, app usage data, and the like. And so if you don't need to collect certain pieces of information, limit the amount of information that you do collect. I think companies should also examine their third-party data flows and be careful about some of the ad technologies that are out there. So we talked about pixels, something called software development kits, these automated pieces of tracking code that you can easily sort of plug and play into your website or app, and automatically starts siphoning off data to third parties. If you're collecting sensitive information, if you're collecting identifiers, even things like mobile ad IDs, a lot of categories of identifiers can be used to sort of trace back to an individual. You really need to be careful and examine your legal obligations before using pixels, SDKs, and some of the similar ad tech tools. Another point I'd make is that violations of these laws, if you're not paying attention, can be costly. Each of these settlements I mentioned resulted in multi-million-dollar payments, either through civil penalties or consumer redress programs. And to bring it back to health information, another point I'd like to hammer home is context matters. And so when we talk about BetterHelp, again, email address, people might not think that's a piece of health information, but when that personal identifier is associated with the use of a mental health, an online therapy platform, again, information about your mental health, the fact that you might suffer from a mental health condition, can be inferred. So those are some of the sort of highlights I'd point out from those lines of cases.
Great, that's super helpful. So affirmative express consent seems to be the name of the game here if you are going to handle this type of information and share it with others. What can you tell us about what that means, and how companies should look to obtaining that type of consent in this context?
Yeah, so affirmative express consent, I think, is something that's very rigorous. We identified and defined what that means in each of our orders in GoodRx, in Premom, and BetterHelp. But it means a lot of things that companies need to pay attention to. So first, it obviously has to be voluntary. Second, importantly, the consent has to be very clear and conspicuous and explain all of the material information. And importantly, the consent has to be separate and apart from, a privacy policy, the terms of use, the terms of service, similar types of disclosures. It can't be something that's buried that consumers don't actually see. I could talk a little bit about what's not affirmative express consent. Making retroactive changes to your privacy policy, and sort of assuming that because you're continuing to use the service, you've consented. That doesn't cut it. Also, there's been a lot of talk about dark patterns, ways in which companies don't, trick consumers into providing their consent. That's another thing that we have defined in our orders that is certainly not a mechanism by which you can obtain affirmative express consent. But I think the takeaway here is to make sure that it's separate and apart from your privacy policies and other sort of long lists of disclosures, that it's clear and conspicuous to consumers, and that you're collecting it or getting consent at the time of collection. Another thing to point out is that, FTC guidance on notice and consent has said that, not only do you have to get consent when you share the information, but you also have to get it when you collect the information. So it's about both collection and sharing of sensitive information. Now, this comes with a big but. I think there has been a movement away from the notice and consent regime that many folks are talking about. So a couple things. First, there are certain things that you should never do, even with consent, right? And so one of those things I would say is using sensitive, personally identifiable health information to advertise. You're using really sensitive information that can be disclosed in ways that consumers don't expect, that can lead to a lot of sort of harm down the line. For that very reason, platforms like Facebook, Google, a whole host of companies that do online ad targeting say that it's prohibited, that it's completely banned. There are self-regulatory organizations like the DAA that also say that using health information to advertise shouldn't be done. So, I would encourage companies to really think carefully about the consequences of doing this, the harm that can flow from, using health information to advertise, even with consent. And again, third-party companies like Facebook and Google won't even allow you to do it, and it is a violation of their express terms. But the most important point I want to make on this, though, is there has been a movement away from, there's this idea that notice and consent is not enough in our modern economy, right? That a lot of the services that we use to do things like obtain medication or to do our homework, we really don't have a choice. There's really no way to participate in our modern economy without using these services. Not consenting is essentially being left out of the world. And so there's this idea that notice and consent really isn't giving consumers a real choice, that people are forced into accepting terms that they might not understand, and that rather than having a notice and consent regime, what's needed is bright line rules of the road that tell all companies sort of how they can and cannot use personal information. As I mentioned earlier today, we actually don't have a national privacy law. We have some patchwork of state laws. The FTC recently, in lieu of federal privacy legislation, we've proposed a commercial surveillance rule. And so we're taking steps to potentially develop rules of the road when it comes to giving companies guidance on how they can, or basically creating a law that tells companies how they can and cannot use data. It remains to be seen what will come of that process. Last year, we saw public comment on sort of most harmful data practices out in the industry that the FTC should pay attention to. The FTC has taken in all those public comments. It's possible that a rule may come of this. It's possible that it may not. So stay tuned.
Okay, thank you for All very helpful. I think it would be it would be helpful to just tease out this affirmative express consent notion with, I think what I heard you say, which was a little bit of a tension that you couldn't even get consent for certain practices. So can you just clarify that a little more? Are you saying affirmative express consent is not effective for certain practices?
I think what I'm trying to say is there has been an idea floated that, you know, affirmative express consent as a practice in general, may not actually be an effective means of protecting consumers. That even if consumers do consent, there's this idea that, the consent might be forced in the sense that consumers need to access a certain app to get their medication, do their homework, things for which they actually don't really have a choice. So that was the point I was trying to make. And so the FTC, there's this idea that, what is needed are more firm rules that tell companies what they can and cannot do, as opposed to putting the obligation on consumers.
Understood. Okay, that's very helpful. I know we wanted to also unpack a bit the joint notice that the FTC sent out with HHS. So why don't we just touch on that? If you can explain what that was and really how this all. I think there's a through line to all of this, which is your advertising technologies are now under the microscope at the FTC on sites and apps that are deemed to be health related. But why don't you just talk about that and again, as you've done so beautifully, just explain kind of the consequences for us as practitioners.
Yeah, sure. I think so. Just to kind of summarize, we recently sent joint letters along with our colleagues at the Health and Human Services Office for Civil Rights. It's the agency that administers and enforces HIPAA. And essentially, we're building on what we've said with GoodRx, with Premom, with BetterHelp, that companies need to be careful about their use of automated tracking tools in the health context, because information can be shared sometimes unintentionally that is sensitive, personally identifiable, and that is contrary to companies' policies. And so we sent these letters to approximately 130 companies, I think in hospitals, telehealth platforms, reminding them to examine their obligations with and really understand how they're sharing data, who they're sharing it with, and what information is being shared. And I think this comes back to, some of the privacy compliance stuff we talked about earlier that companies like BetterHelp, GoodRx, Premom fail to do. Some best practices that companies need to think about are, making sure that you're vetting your third-party data flows, that you know who you're sharing data with. If you're using, ad tech tools like the Facebook Pixel, make sure you're disclosing that adequately, that you are not sharing any sensitive categories like personally identifiable health information, that the information you are sharing in some cases, if it is sensitive, is anonymized. When we talk about having internal privacy compliance programs, in addition to vetting your third-party data flows, practices like data minimization, collecting only the data you need and keeping it only for as long as you need it, deleting it when it's no longer necessary, limiting data access to only those employees who need to have the information. So, giving access to sensitive health information to an intern in the marketing department may not be a good idea. Training employees on their, legal obligations, on the company's internal privacy policies, on any HIPAA obligations and FTC Act obligations should they exist. And importantly, and this is something that the companies that we brought enforcement actions against didn't do, sharing data only with contractually bound service providers, companies with which you have a service provider agreement that limits their use of personal and sensitive information only to providing services back to you, the company. And also auditing your agreements with those companies, making sure that the folks at your company are actually complying with the service provider agreements, ensuring that third parties are, taking steps to protect the information as well. And of course, having privacy be a consideration at all stages of product development, from the start to deployment of products, apps, and services. So those are some things that, we often like to tell companies to take a look at. And I think the failure to do those things are things that really come out in the complaints we brought against GoodRx, BetterHelp, and Primum.
Great. And those of us practicing, those are familiar. We're seeing those pop up in not only the health data privacy laws, but obviously in the state data privacy laws and regs. So many of those concepts are being repeated.
Definitely.
So as we've been talking, it's clear that this is, as I said earlier, ad tech, which can be very confusing to us mere mortals of lawyers. And I did note that the FTC has an Office of Technology, and there are technologists. And here in California, our privacy agency made a big deal at a recent board meeting that, rightfully so, that it had hired several technologists, and it was kind of a groundbreaking event. They didn't even know how to classify people for payment purposes. It was so novel. So I think it's very interesting to me to understand what role those technologists play, how you interact with them, and how, if you can talk about, what role they may have played in some of these enforcement actions.
Yeah. So I think it's a great development. At the FTC, we've always had technologists, but we've recently made a major push to aggressively hire and bring on some of the tech talent that I think has been a great addition to the agency. We recently established our Office of Technology, and now we're sort of backing that up with all kinds of new hires. I think they are an asset and have complemented my work and been integral parts of cases and investigations. I'm a lawyer by training. I have a background in government. I don't read code. I don't have very many technical skills from my background. And so they bring a lot of, technical expertise, skills from industry, academia, research skills, and I think importantly, the perspective of non-lawyers. So I think it's fair to say that they certainly play a big role in supporting our cases and investigations, from, reading documents and helping to interpret technical and complex documents and pieces of information. But they don't only work on cases. They also do research, and they work on policy-related efforts at our agency, non-enforcement stuff like our 6B studies, requests for information, policy statements, congressional briefings, and other initiatives. And they also help with workshops, conferences, consultations, and they highlight key trends and best practices. So overall, I think this is a great and necessary development. I will say that when I first started working on some of the health privacy matters, this was my first foray into this world of pixels. I had never heard of an SDK, a software development kit, before, and it was quite daunting. There was a steep learning curve, but with the help of technologists, doing my own due diligence, watching YouTube videos, asking questions, really exacting questions of the companies, I was able to kind of piece together the information, and certainly the technologists played a huge and important role in that process.
You jumped ahead of the question I was going to ask you, which is, for those of us who can't run down the hall and say, can you explain how I can detect this code or what's going on here? How would you recommend that folks get up to speed on these technologies that are, right at the forefront of what the FTC is looking at these days? How did you do it?
Yeah. So, in addition to relying on our in-house tech expertise, there are a lot of public resources, like when we talk about the Facebook Pixel or the Google Pixel. These companies publish a lot of information and policies about how they work, the information they're supposed to collect. So there are a lot of key pieces of information you can get from the companies themselves. I have found a lot of YouTube videos to be really helpful. Often they were meant for coders and marketing people who were implementing the the code and using them to advertise. But watching them and getting that perspective was immensely helpful. So yeah, there's no sort of one way to learn it. But I'm someone who does not have technical background. This was all brand new to me, and with some extra help and a little bit of research, you can figure it out.
I think that is the plight of all data, not the plight. It's to me, the exciting part of being a privacy lawyer is that you're always having to learn, and you get to learn, and you get to immerse yourself in the next thing and really understand it, and really try to understand it at a deep level.
Definitely.
Yeah. Well, speaking of journeys to privacy, I think it would really be interesting to hear about how you landed here. Kind of what was your journey, and
Yeah.
if there are lawyers of all ages and levels of experience in privacy on this call, and I think people are always interested. How do I get to where you are? Advice, all that good stuff.
Yeah, sure. Happy to chat about that. So I started my career I worked at a firm in San Francisco Bay Area, was in the litigation group, and the cases I worked on were private civil litigations, and got great training, great experience there. But me personally, I've always had a passion for public service, for government, wanting to make a difference for, ordinary people. And so when I learned about the FTC through friends, through work, kind of thought this would be the perfect place to do that. I applied and sort of got the job and switched over in the end of 2016. I started in the San Francisco office where, we work on, in the San Francisco office, all kinds of consumer protection cases. So I got experience doing privacy, consumer fraud cases, false advertising, really the whole gamut, and really developed an interest and expertise in privacy and security matters, and decided I kind of wanted to sort of focus on that full time. And we have certain shops here in headquarters in Washington, D.C., where you can focus on one case, one type of case 24/7. And so I transitioned to the Division of Privacy and Identity Protection here in Washington, D.C., and now I work on data privacy and security matters all the time. It has been an amazing experience working at the FTC. I think one of the sort of best parts about the job is all of the responsibility that you get early on in your career. And so you sort of, as a government attorney, are thrown right in to court hearings, depositions, trials, brief writing, things that in the private sector sometimes you don't get for many years later. So working in the government, sometimes resources is an issue. We don't have the resources that the private sector does, but we certainly get the hands-on experience. And I think that's been one of the best parts of the job. Again, getting money back for consumers is also always very gratifying. And, having your cases make an impact on the industry, sort of promoting change, getting to sort of rectify data misuse and data abuses has been something that's been really gratifying for me. And so I would say to anyone who's interested in data privacy law or working for an enforcement agency, it's been a really great experience. It's been a really gratifying journey, and I would not trade this job for the world.
And toot your horn a little bit about, tell us, it would be interesting to just know the role you played in GoodRx, because that really feels like this was a big turning point.
Yeah.
And what role did you play?
Yeah, so I was the lead attorney on that case. That case sort of stemmed from a Consumer Reports article in 2020, where Consumer Reports did some sort of investigation into the data sharing practices, and so I internally led that investigation. That ultimately sort of led the settlement negotiations there as well. And then, that ultimately resulted in the case, the filing of the complaint and the settlement that we were talking about. And again, that was another great experience. Learned a lot about the ad tech industry. Some of it was frightening, quite frankly. But I am sort of heartened by the fact that when I talk to people who work in this space, everyone tells me how much, this has really moved the needle in terms of first providing some guidance about the kinds of things that companies should not be doing, but also, making it clear that, the kinds of data sharing that we were talking about, many people said it was industry norm or industry practice prior to GoodRx. And what I've heard anecdotally is that many of those practices have changed. So that is something that's very encouraging. So that's been a great experience.
I'm sure you can't tell us this, but I'm going to ask, and of course, understand that you can't if you can't answer it. But was this a matter that, like, where you read the article and then did you kind of take ownership over it? And
I'd rather not say, but
okay, I thought you might not be able to, but
I will say that the cases that we do bring come to us in all kinds of ways, right? We get consumer complaints that lead to opening of cases. We all are consumers ourselves at the FTC and read the news and use products. We work with our state and federal enforcement partners. So there's no one way in which we get case referrals or learn about cases. It really runs the gamut.
Great. Well, this has been so helpful. I think that 2023 and looking into 24 will continue to be the years of health data privacy with not only what you're keeping yourself busy with, but also these laws that are going to be coming into effect next year. So Thank you so much for taking the time, Ronnie. I really appreciate it. And thank you all for joining. As we said, it has been recorded. So it will be available through the CLA privacy law website. And also, while we didn't offer full MCLE credit for a full three credits, at least in California, those of you who wish can do a self-study credit with this. And the information is in the registration link. All right. Thanks again.
Thanks,
okay.
Sherry.
Take care.
Take care.
All right. Bye.
Bye.